Hello students, here is Ashu Gupta, Assistant Professor. Again welcomes you all on the behalf of the Indraprasth Law College. In today's lecture we are going to discuss about the state territory and territorial sovereignty. First of all, we understand about the state territory or the meaning of territorial sovereignty, according to which as already discussed in the previous chapters or the lectures dealing with the state, a territory is one of the fundamental elements of statehood. Without a territory, an entity cannot be a state, and the notion that a state occupies a definite portion of the earth within which it exercises, subject to the limitation of international law, its exclusive authority to the exclusion of other states lies at the basis of international law. The exercise of such a supreme authority by a state over its own territory is known in international law as territorial sovereignty. The concept territorial sovereignty is confused with the concept of jurisdiction. Some jurists have used the two concepts interchangeably. However, there is a distinction between the two concepts. Territorial sovereignty signifies ownership and possession of a territory, which entitles a state to exercise its authority and jurisdiction over the territory. Jurisdiction justifies competence to affect peoples, properties, and events within a territory. Because territorial sovereignty and jurisdiction are two legal concepts connected to territory and can only be understood in relation to territory. Therefore, in the following two sections, the territorial sovereignty and modes of acquiring territory are dealt with, while jurisdiction will be the subject of the next lecture. We will discuss it later on. In today's lecture, we wholly concentrate on the concept of the territorial sovereignty. If we talk about the territorial sovereignty, a sovereignty in regard to our territory is known as territorial sovereignty, as we already know that. And territorial sovereignty is the right of a state to exercise over its own territory to the exclusion of any other states. Functions of a state. It has a positive and a negative aspects. The first aspect relates to the exclusivity of the right of the state with regard to its own territory, while the second aspect refers to the obligation to protect the rights of the other states. A state exercises its territorial sovereignty within its boundary, and boundary is an imaginary line that delineates the territorial limits of a state. Boundaries are of three dimensions. They include the state land and the maritime domain of its internal waters and territorial sea, the air space and its subsoil. They are either natural, topographical, having physical distinguishable features such as mountains, rivers or lakes, or imaginary and artificial such as lines of altitude and longitude, surveyor lines or posts. Both types have equal legal effects and usually based upon the treaties or the historical title. The sovereignty of a coastal state extends beyond its boundaries over its contiguous zone, over its continental shelf, and over its exclusive economic zone. Moreover, the sovereignty of a state, whether coastal or landlocked, extend over its national vessels. The sovereignty of a state extends also to its national aircrafts. The right to territorial sovereignty enables a state to exercise the fullest measures of sovereignty powers over its land territory, large measures over its territorial waters and airspace, and smaller measures over its continental shelf and adjacent area. In addition, it enables a state to exercise sovereignty over vessels and aircrafts that fly its flag or carry its nationality, which are treated as territory. Corollary to the rights generated from territorial sovereignty, there are duties imposed upon a state. These duties involve the obligation to protect within its territory the rights of other states, together with the rights that each state may claim for its nationals in foreign territory. Many treaties and conventions have been concluded to regulate state sovereignty over land, sea, airspace, and outer space. Over airspace and outer space, there are the 1944 Convention on International Civil Aviation, the Chicago Convention, the 1963 Treaty banning nuclear weapon tests in the atmosphere, in outer space, and underwater, and the 1967 Treaty on Principles Governing the Activities in Exploration and Use of Outer Space, including the Moon and other celestial bodies, that is the Outer Space Treaty. Over the sea, there is the 192 Convention, 1982 Convention on the Law of the Sea, which replaced the 1956 conventions related to territorial sea and contiguous zone, the high seas, the continental shelf, the fishing and conservation of living resources of high seas. And in addition, there is the 1959 Antarctica Treaty. Since the rights generated from the concept of territorial sovereignty can only be exercised in relation to a territory, so it is necessary to know how a territory can be acquired. So, the acquisition of territory we'll discuss in the next lecture. Hope you will understand the whole concept behind the territorial sovereignty and the state territory under this chapter of international law, and you will be enumerated it into your study. We will meet soon again in the next lecture. Thank you very much.